Senate to assess his credibility directly. The respondents relied on the Court of Appeal's decision in Kenya Revenue Authority versus Murgani, a 2010 decision, for the proposition that fairness does not always require an oral hearing, and that provided a body achieves the degree of fairness appropriate to its task, the manner in which it proceeds was a matter for its own institutional judgment. Drawing on local government vote versus Aldrich, as well as the case of Selvarajan versus Res Relations Board and R versus Immigration Appeal Tribunal, the Court of Appeal in the Murgani case concluded that a hearing conducted by way of written exchange may, in appropriate circumstances, constitute a fair hearing. We do accept that general principle as binding on us. However, Murgani is plainly distinguishable on the facts and context that are both material and decisive. That case concerned an administrative determination in which no oral proceedings had been conducted at all. Both parties were in a position of formal procedural equality. The written process was the established mechanism, and the question was simply whether the absence of an oral hearing was fatal to fairness. The present case is fundamentally different. The Senate did not choose at the outset to proceed by way of written submissions alone. It had agreed to a fully adversarial oral hearing with witnesses, examination in chief, and cross-examination. Having adopted that mode of proceeding, the Senate could not, at the moment His Excellency Gachagua was to take the stand as his own sole witness, abandon the adversarial framework it had established for itself without satisfactory reason. To do so was to apply different procedural standards to the two parties. That disparity is the antithesis of equality of arms and is irreconcilable with the constitutional guarantees of Article 47 and Article 50. The Hansard record of the Senate proceedings of 17 October 2024 confirms that following the confirmation by Paul Mwita Senior Counsel to the House that His Excellency Gachagua had been taken ill, several senators who rose to comment explicitly acknowledged on the floor of the Senate that H.E. Gachagua was unwell. Not one of these senators disputed the illness. They acknowledged it and then proceeded, notwithstanding that acknowledgement, to oppose the adjournment application. The circumstances must also be taken within the directions issued by the Speaker of Senate at the time. The Honorable Speaker stated in part as follows, I quote, "As this process is time-bound by the Constitution, to be concluded in not more than 10 days pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday the 19th of October 2024, the only window open to the Senate, if it is so obliged, the requests for adjournment sought by counsel for the Deputy President would be to gazette Saturday the 19th of October 2024 as a further and final day for hearing of this matter. Honorable Senators, ladies and gentlemen, such a request is not made to the Speaker but to the Senate and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter. this being the last day allowed by the Constitution of Kenya for these proceedings to conclude. I close the quote. The Speaker's communication meant that it was in fact open to Senate to adjourn the sitting up to Saturday. The significance of that course of conduct cannot be overstated. The Senate, despite having the option to adjourn and having expressly acknowledged the incapacity of the party before it, nonetheless proceeded to determine his fate in his absence.
That was not a proper exercise of constitutional discretion. It was a negation. We are convinced that had the Senate exercised its discretion genuinely, open-mindedly, and with a conscientious regard for the constitutional rights of His Excellency Gachagua, and had it directed its mind to the miscarriage of justice that its refusal was plainly going to occasion, this was a case in which the circumstances unambiguously called for an adjournment to be granted at least to the next day.
That conclusion is firmly supported by the Court of Appeal's pronouncement in Kariuki versus Attorney General, a 2014 decision, where the court held as follows, again I quote, while bearing in mind that whether to grant an adjournment or not is discretionary, and appellate courts are loath to readily question the exercise of discretion by the trial court, nevertheless, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of applications for adjournment of criminal trials, nevertheless, because of the constitutional basis of that right and the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. In denying the appellant's application for adjournment, the court-martial in that particular case also did not address its mind to the critical question of whether denial of the adjournment would occasion a miscarriage of justice. In Job Obanda versus Stage Court International Services Limited and another, this court, that is the Court of Appeal, was emphatic that where, amongst others, a judge fails to apply his mind to the question whether a miscarriage of justice might be occasioned to a party who is refused an adjournment, that would constitute sufficient basis upon which an appellate court would be entitled to interfere with the exercise of jurisdiction, close of quote. We say so with a full appreciation of the non-derogable nature of the right to a fair trial. It is not a right that yields to constitutional timelines or political exigencies. It is an absolute constitutional guarantee, and its violation cannot be justified by reference to any competing constitutional interest, however weighty or pressing that interest may be. This finding becomes even more compelling when one considers the Senate's misdirection in its interpretation of Article 145(4)(b). Senate appeared to imagine that it had 10 days within which to dispense the impeachment hearing itself. Yet, the text and structure of that provision, according to us, make it clear that the 10-day period was intended to apply exclusively to the special committee once constituted. We have addressed in detail our understanding of Articles 145(3)(b) and 145, sub-article 4 to 6 in the preceding section of this judgment, and we do not propose to repeat that analysis again here. Finally, we wish to make brief observations on the affidavit of Dr. Daniel Kibuka Gikonyo, sworn on the 28th of April 2026, which was admitted into evidence by leave of this court and tested by cross-examination when Dr. Gikonyo attended to give oral testimony. There is no doubt that the affidavit was not before the Senate on the 17th of October 2024 when the request for adjournment was made. And on that ground, we do agree with Senate's submission that it could not have informed the House's determination at the time. The affidavit was additionally filed almost 2 years after the petitions were instituted, and no explanation was offered to us, including by Dr. Gikonyo himself, for that delay. For those reasons, we do not attribute significant probative value to it. The circumstances, as we have analyzed, were independently and collectively sufficient to warrant a reasonable adjournment. Dr. Gikonyo's evidence neither adds nor detracts from that conclusion.
In conclusion, therefore, upon careful consideration of the consolidated petitions, the responses filed, the submissions of counsel, and following our deliberations and analysis, we now pronounce ourselves on the issues presented. On jurisdiction, we hold that the impeachment proceedings challenged herein are justiciable. This court possesses jurisdiction under Articles 22, 23, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. On allegations of bias, the allegations of bias, predetermination, and conflict of interest advanced against the speakers, members of parliament, and senators are unsubstantiated. They rest on political inference and suspicion rather than objective evidence capable of satisfying the required threshold. On public participation, we are satisfied that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua met the constitutional threshold. The Senate did not violate Articles 10 or 118 by failure to conduct